A paralegal is an individual, qualified by education, training or work experience who is employed or retained by a lawyer, law office, corporation, governmental agency or other entity and who performs specifically delegated substantive legal work for which a lawyer is responsible. However, this is not the case in Ontario, Canada, where paralegals are independent legal practitioners, licensed by the Law Society of Upper Canada to provide legal services within their scope of practice to members of the public. Licensed paralegals in Ontario may manage their own legal firm or be appointed as a justice of the peace, and have the opportunity to seek employment as a municipal or provincial prosecutor. Overview. A paralegal is a person trained in legal matters who performs tasks requiring knowledge of the law and legal procedures. A paralegal, like a lawyer, can be employed by a law office or work freelance at a company or law office. Paralegals are not allowed to offer legal services directly to the public on their own and must perform their legal work under an attorney or law firm. Many paralegals may have their own company and be called law agents, providing services such as settlements, court filings, legal research and other auxiliary legal services. These tasks often have instructions from a solicitor attached. Other tasks may only be the title of a task to be performed with no instructions of how it is to be completed. Often the instructing legal entity relies on the expertise of a paralegal in regard to how compliance is to be met in completing tasks. A paralegal is protected under the conduit theory, which means he or she is working as an enhancement of an attorney and what he or she does is due to instruction by the attorney and the attorney is ultimately responsible. Paralegals often have taken a prescribed series of courses in law and legal processes. Paralegals may analyze and summarize depositions, prepare and answer interrogatories, draft procedural motions and other routine briefs, perform legal research and analysis, draft research memos, and perform case and project management. Paralegals often handle drafting much of the paperwork in probate cases, divorce actions, bankruptcies, and investigations. Consumers of legal services are typically billed for the time paralegals spend on their cases. The definition of paralegal varies by country. In the United States, they are not authorized by the government or other agency to offer legal services in the same way as lawyers, nor are they officers of the court, nor are they usually subject to government-sanctioned or court-sanctioned rules of conduct. In contrast, in Ontario, Canada, paralegals are licensed and regulated the same way that lawyers are. In Ontario, licensed paralegals provide permitted legal services to the public and appear before certain lower-level courts and administrative tribunals. In Ontario, paralegals are licensed by the Law Society of Upper Canada. Ontario is the only jurisdiction in the Western Hemisphere where paralegals are licensed and the profession is regulated as officers of the court. Licensed paralegals operate within a defined scope of practice, representing clients in matters such as provincial offences, immigration, landlord and tenant disputes, labor law, small claims court, and specific criminal matters. They are currently not permitted to represent clients in family court or wills and estates. By virtue of their office, licensed paralegals are commissioners for taking affidavits. In the United States, paralegals originated as assistants to lawyers at a time when only lawyers offered legal services. In those jurisdictions where the local legal profession, judiciary is involved in paralegal recognition, accreditation, the profession of paralegal still basically refers to those people working under the direct supervision of a lawyer. The profession of paralegal varies greatly between the states, because some states do require paralegals to be licensed. In other jurisdictions, however, such as the United Kingdom, the lack of local legal profession, judiciary oversight means that the definition of paralegal encompasses non-lawyers doing legal work, regardless of whom they do it for. Although most jurisdictions recognize paralegals to a greater or lesser extent, there is no international consistency as to definition, job role, status, terms and conditions of employment, training, regulation or anything else, and so each jurisdiction must be looked at individually. Official definitions. Various legal organizations offer official definitions of a paralegal. These definitions typically have slight differences. Definitions offered by major organizations include, from the National Federation of Paralegal Associations, USA, a paralegal is a person qualified through education, training or work experience to perform substantive legal work that requires knowledge of legal concepts and is customarily, but not exclusively, performed by a lawyer. This person may be retained or employed by a lawyer, law office, governmental agency or other entity, or may be authorized by administrative, statutory or court authority to perform this work. Substantive shall mean work requiring recognition, evaluation, organization, analysis, and communication of relevant facts and legal concepts. From the National Association of Legal Assistants, USA, legal assistants, also known as paralegals, are a distinguishable group of persons who assist attorneys in the delivery of legal services through formal education, training and experience. Legal assistants have knowledge and expertise regarding the legal system and substantive and procedural law which qualify them to do work of a legal nature under the supervision of an attorney. In 2001, NALA adopted the ABA's definition of a paralegal or legal assistant as an addition to its definition from NALS. The Association for Legal Professionals, USA. A legal assistant, paralegal is a person qualified by education, training or work experience who is employed or retained by a lawyer, law office, corporation, governmental agency or other entity, and who performs specifically delegated substantive legal work for which a lawyer is responsible. From the American Association for Paralegal Education, paralegals perform substantive and procedural legal work as authorized by law, which work, in the absence of the paralegal, would be performed by an attorney. Paralegals have knowledge of the law gained through education, or education and work experience, which qualifies them to perform legal work. Paralegals adhere to recognized ethical standards and rules of professional responsibility. From the United Kingdom's Institute of Paralegals, a paralegal is a non-lawyer who does legal work that previously would have been done by a lawyer, or if done by a lawyer, would be charged for. From the Paralegal Society of Ontario, a paralegal is an individual qualified through education or experience licensed to provide legal services to the general public in areas authorized by the Law Society of Upper Canada. From the United Kingdom's National Association of Licensed Paralegals, a person who is educated and trained to perform legal tasks but who is not a qualified solicitor or barrister. From the International Paralegal Management Association, a legal assistant or paralegal is a person qualified by education, training or work experience who is employed or retained by a lawyer, law office, corporation, governmental agency or other entity who performs specifically delegated substantive legal work for which a lawyer is responsible. Under this definition, the legal responsibility for a paralegal's work rests directly and solely upon the lawyer. From NALS. The Association for Legal Professionals, USA. A legal assistant, paralegal is a person qualified by education, training or work experience who is employed or retained by a lawyer, law office, corporation, governmental agency or other entity, and who performs specifically delegated substantive legal work for which a lawyer is responsible. Difference between paralegals and lawyers in the United States. The greatest differences between lawyers and paralegals are that lawyers give legal advice, can set fees, appear as counsel of record in court, and sign pleadings in a representative capacity. A paralegal who attempts to do any of these acts will be in violation of the unauthorized practice of law statutes in most U.S. states. Paralegals are responsible for handling tasks such as legal writing, research, and other forms of documentation for the lawyers for whom they work. Difference between paralegals and legal secretaries. A legal secretary is generally a secretary who has a basic understanding of legal terminology and the specific formatting required by a particular court or government agency. Legal secretaries are also typically responsible for keeping case files organized and indexed, often taking on the duties of a file clerk. Although legal secretaries may be trained to prepare some basic legal papers and letters, they generally have little or no knowledge of particular legal doctrines, statutes or regulations, and typically have no training or experience in conducting legal research or drafting legal documents, pleadings, motions, briefs or other court papers. On the other hand, a typical paralegal in the United States can perform all of these tasks under an attorney or law office. Paralegals bill for their time at a higher rate than legal secretaries. Education, training, and certification. Most paralegals have completed a formal paralegal education program. However, some paralegals have only on-the-job paralegal training. Formal paralegal education programs may result in an associate degree, bachelor's degree, master's degree, or paralegal certificate. Many paralegals have completed all of their training before entering the profession, while others have completed their education while working their way up from the mailroom in a law firm. Many paralegals take continuing legal education courses to fulfill the requirements of their firm, state, or association. United States. In the United States, there is no such thing as a paralegal licensed by a government body. Rather, paralegals can be registered, certified, or certificated by private organizations. There are two major national organizations that offer professional certification to paralegals who meet voluntary regulation standards. The National Association of Legal Assistants, established in 1976, and the National Federation of Paralegal Associations, established in 1996. Both NALA and the NFPA offer professional certification exams that should not be confused with a paralegal certificate offered by an officially accredited college or university. Communications, ethics, legal research, judgment and analytical ability. American legal system and 4 subsections selected by the applicants from a list of 9 substantive areas of the law. These subsection tests cover general knowledge of the following practice areas: administrative law, bankruptcy, business organizations, civil litigation, contracts, criminal law and procedure, estate planning and probate, family law and real estate. After successful completion of the examination, NALA awards the paralegal the CLA or CP designation. Both the CLA and CP designations are proprietary trademarks owned by NALA. Paralegals who have attained further education and received a paralegal certificate are referred to as certificated, unless they have passed the examination and have been awarded the certified designation. Additionally, those paralegals who receive the certified paralegal designation then have the opportunity to earn the advanced certified paralegal designation. There is a 45 to 50% pass rate for persons taking the NALA exams. The NFPA offers its non-accredited paralegal advanced competency exam, which is a 4-hour exam on a variety of legal topics. Those who pass that exam can call themselves PACE-registered paralegals and display the RP designation. NFPA's core purpose is to advance the paralegal profession and is committed to the profession's code of ethics. Some states have considered the licensure of paralegals. Whether paralegals should be licensed or certified is one of the most important issues for paralegals today. California. In California, under Business and Professions Code 6450, a paralegal must have at least one of the following: 1. An ABA-approved paralegal certificate. 2. A paralegal certificate comprising at least 24 semester units in law that has been accredited by a national regional accrediting organization or approved by the Bureau for Private Post-Secondary and Vocational Education. 3. A bachelor's degree or advanced degree in any subject and at least 1 year of experience performing legal tasks under the supervision of an attorney that has at least 3 years legal experience in California himself. The attorney must sign a written declaration stating the paralegal is qualified to perform legal tasks. 4. Before December 31, 2003. Have completed a high school diploma or general equivalency diploma in a minimum of 3 years of law-related experience under the supervision of an attorney that has at least 3 years legal experience in California himself. The attorney must sign a written declaration stating the paralegal is qualified to perform legal tasks. Up until Bus and Professor Code 6450 was signed into law by Governor Gray Davis in 2000, there was little regulation of paralegals in California. One of the purposes of regulation under Bus and Professor Code 6450 was to shut down the paralegals who were providing self-help legal services to consumers. There had been relatively few consumer complaints against paralegals. Instead, most of the complaints were from lawyers who urged the California State Bar to police the unauthorized practice of law. In response, the State Bar appointed a public protection committee to look at the L.A. Bar's claim. Then, in 1988, the Public Protection Committee unanimously recommended that the California legislature completely abolished the state's UPL laws. It further concluded that independent paralegals should be allowed to provide all types of legal services as long as they are registered with a state agency and disclose their non-lawyer status to all customers. After many local bar associations reacted in dismay, the California Bar then appointed a third group to restudy the issue. This commission largely agreed with the conclusions of its predecessors and recommended that non-lawyers be authorized by the California Supreme Court to deliver legal services in several major areas, under the terms of a licensing scheme that would be supervised by an independent state agency. This development culminated in some paralegals being forced to give up the title paralegal for legal document assistant in order to administer legal services directly to the public in the allowed areas. Under California Bus and Professor Code 6400, paralegals who are members of professional associations are also bound by those associations' codes of ethics, many of which include sections prescribing that members not offer legal services directly to the public without the supervision of an attorney or law firm. South Africa. Legal assistants or paralegals must have extensive knowledge of the law and the administration of justice. Their duties may include: this program is uniquely designed to impart a comprehensive overview of all aspects of paralegal specialization and an understanding of individual rights and the rights of others. Paralegal offers the use and application of skills and competencies related to criminal law and procedure, civil litigation, wills and estates, dispute resolution, legal advice, property law and conveyancing, as well as legal office practice management and debt collecting, counseling. Paralegals in South Africa are hired mostly by Legal Aid South Africa, big corporations, patent law firms, legal firms, estate agents, government departments, etc., to provide legal support to those corporate world. Legal support may be by legal research, investigation, inspectors, legal advice or legal assistance. Certification may be acquired at Sichuan University of Technology National Diploma in Legal Assistance, Paralegal, University of Johannesburg Diploma in Paralegal, UNISO National Diploma in Law, South African School of Paralegals, Intech College Diploma in Paralegal, South African Law School Qualification in Paralegal, Damlin College Paralegal, Boston City Campus Paralegal Certificate. Salaries range from R$60,000 to R$45,000 per year depending on experience. Newly established law firms in South Africa are likely to hire qualified paralegals with 3-year qualification in legal studies to provide legal assistance. Though the South African Law Society and the Minister of Justice do want to come with regulation to guide paralegals in South Africa just like Canada and the USA. Many practicing attorneys and advocates did disapprove in many instances. However, the new legislation is pending. Penalties for unauthorized practice. Paralegals are restrained from exercising independence and prohibited from providing even basic legal advice to consumers of legal advice. In her book, Access to Justice, Stanford law professor Deborah Rhodes states, over 4/5 of surveyed attorneys have supported prosecution of lay practitioners, and the profession has repeatedly blocked licensing proposals that would enable independent paralegals to offer routine services. Many local, state and national bar associations have recently launched initiatives to broaden the definition, raise the penalties, and increase the enforcement of unauthorized practice prohibitions. In some areas, legal document assistants actually advertise themselves as paralegals. Many states, including Florida, have enacted laws or bar rules which require any person referring to himself or herself as a paralegal to work under the supervision of a licensed attorney. This rule would prohibit those individuals working as independent paralegals from using the title paralegal. Salary. In the United States, as of May 2012, the median annual salary for a paralegal was $46,990. Paralegals working for the U.S. federal government average around $65,000 per year, while state and local government paralegals earn around $45,000 to $50,000. In Ontario, Canada, paralegals may start at $50,000 a year and can make up to $100,000 or more depending on experience, type of employment, and if they manage their own legal firm.